and cultural heritage law, intellectual property law, luxury goods and fashion law, collectibles, NFTs, and musical instruments. Leila will be speaking about copyright law related to art and AI, including the recent U.S. Supreme Court ruling on this topic. She represents artists, art collectors, museums, art galleries, dealers, nonprofits, estates, foundations, and foreign governments. An internationally recognized expert on art and heritage crime and law, Leila has lectured at esteemed institutions including the Frick Collection, Victoria and Albert Museum, the Neue Galerie, and the Philadelphia Museum of Art. She's appeared in major news outlets including the New York Times, ABC News, LA Times, the art newspaper Artnet, Forbes Magazine, The Guardian, Time Magazine, and the Wall Street Journal. She has been published in dozens of legal journals and art publications and has led scholarly contributions published in books. Leila currently serves as the chair of the Art Law Institute for the New York County Lawyers Association. She teaches international art and cultural heritage law at Fordham University School of Law, in addition to art, crime, and the law at New York University, and was previously the executive director of the Lawyers Committee for Cultural Heritage Preservation. Lovely to have you here with us today.
Thank you. Thank you for the lovely introduction and also for hosting me to discuss an issue that's really interesting, that's quickly developing, and I think interests people around the world, whether they're artists, people in the art world, or people in technology. So thank you for inviting me today.
Thank you so much for joining us. And so without further ado, we'll dive right in. You've prepared a short presentation for us, and please just let me know when you'd like the next slide put through.
Thank you. So before I begin, I'll begin with a caveat that I am a US attorney. I'm barred in New York. And so really my work focuses more on US law in terms of copyright. But it seems that at this point, US law, US courts, and the US Copyright Office have provided some guidance on the direction that we're going in terms of AI generated art. But of course, I'll open this up to questions, and if there are any international lawyers who are participating, I'd be happy to hear questions from them. But really, my focus is U.S. law. So, Miriam, we can go to the first slide. So, copyright law has a very long history, and it dates back to 15th century Europe. It was born through efforts made by the church and by sovereign powers to control printed materials. These controls granted licenses to only select printers to reproduce books, essentially controlling the dissemination of information. But then copyright laws developed over the centuries, ultimately appearing in the United States Constitution through the Copyright Act of 1790. But this area of the law is ever changing, with its application growing not only from books, but to broader applications, with copyrights protecting fine art, film, music, photography, and nearly every area of creative works. As a US-based attorney, my work focuses on US copyright law, so that will be the focus of my talk today. And copyright currently is really a topic of interest to everyone in light of the Supreme Court's decision just last month. It was the first week of June, I believe, or sorry, in May. So the decision last month in Goldsmith versus the Andy Warhol Foundation for Visual Arts. And I will touch upon that case in a few minutes. But before I get there, I wanted to give a little background on copyright law. So Miriam, the next slide, please. So copyright is what it sounds like. It's the right to copy something. And as I mentioned, stems from this right for printers to copy books. It's a form of protection granted by law for original works of authorship. And you'll see how that language is really important when we talk about AI art and different applications of copyright. What does it mean to be original? And this is something that courts and the Copyright Office have struggled with for over the centuries. So this is copyright is protection for original works of authorship fixed in a tangible medium of expression. So it needs to be something tangible. And so you cannot just copyright an idea. You can only copyright that fixed expression of the idea. That expression must be recorded in something tangible. So owners of those copyrights have the exclusive right to copy the works, to reproduce, to publish, to sell, or to distribute copyrighted material, including the right to create derivative works. So works like sequels to works, works that are derivative of that original work of authorship. However, there is one major exception, and this exception is generally what's litigated over when we have a copyright dispute. And that exception, as you see on the screen, is the fair use exception. It's an exception under Section 107 of the Copyright Act. This exception allows someone else to use a copyrighted work without receiving permission from the copyright holder. Fair use has generally been allowed for criticism, for commentary, for news reporting, teaching, and scholarship and research. So I think a really simple example of that is kind of what I'm doing today. You'll see that I have a couple of images on my slides that are used as an illustration for teaching, for instructing about this area. So in the lectures that I give at Fordham Law School, I'll have images of artwork as illustrations of the material, and it's really used for educational purposes. It's not being used commercially. So that generally is being seen as a fair use. So in determining whether there's a fair use, courts use a four-factor analysis that's set forth in Section 107, which you can see on the screen. I'm not sure how large the font is for viewers. It's kind of small for me, but I list the four factors there. But the challenge really of this four-factor analysis is that it really does, in many cases, involve subjective judgments. What is the nature of a use? Is it commercial? Is it for nonprofit educational purposes? And as you can imagine, sometimes the purposes kind of bleed into one another. You might have a purpose that's educational, but at the same time commercial. You can imagine the sale of a commercial book that's an educational book. So you see that there's this bleeding into what is the nature of a copyright? What amount of the material is being taken for a secondary work, this work where an author is claiming fair use? And then, of course, what is the effect on the market if you're using a similar image, if you're using someone else's image in your works? So this, I think, all kind of relates back to the same issue or this larger issue in art law, that it's difficult to make judgments on art matters. And I have a good example on the next slide, Marion, if you can move forward. It's been difficult for judges for at least or over a century to make decisions on art, even when it comes to that simple question of what is art? And here's an image of a work, of a sculpture called Bird in Space by Brancusi that was the subject of a litigation back a century ago in the early 1920s. And this question came before the court: what is art? In the context of the Tariff Act of 1922. And the judge in that case needed to determine whether the sculpture that you see on the right-hand side, whether that was a piece of art, because a work of fine art would be exempt from the imposition of a 40% tariff upon the import of the work into the United States. So in order to be exempt from this tariff, the artist said, this is a piece of work. And US Customs questioned that and said, no, you actually have to pay this tariff. You are importing this object. It's not a piece of art, it's just an object. So it was really up to the judge to determine, is this an art object or not? And the judge went through an analysis trying to determine this really difficult question: what is art? That definition is really hard to create, especially when you think about the nature of art and the ever-changing nature of art, which is why we're here today talking about AI-generated art. And in this case involving bird and space, the judge looked at a few different factors. He considered a few things in determining the nature of the work as being an artistic work. He looked at the work itself, its aesthetic. And luckily for Brancusi, the judge really liked this work. He described it in really positive terms as being graceful and kind of capturing the essence of flight. He also looked at the identity of the creator. It was a recognized artist, and as an artist recognized by other artists as someone who had merit in his field. The judge looked at the artist's intention and also the opinions of professionals in the art world. So during the course of this trial, various experts were brought into the court to discuss this work. What was the meaning? Who was the artist? What was the intention? What was the skill involved? And after looking at all that evidence, it was determined that this piece is a work of art. And we don't have that much time to delve into this today, but there are a line of cases involving these questions, and they often do come up in the context of taxes and tariffs. Do we define something as a piece of art and make it exempt from a tariff? And some of these cases are really challenging for judges, and that's come up often with either appropriation art or works like Duchamp's ready-mades. If you take a urinal and put it in a different context, is it suddenly art? And you can imagine how legal judges have a lot of difficulty with these decisions. So these are kind of some of the same questions we're facing today with AI-generated art. When does something stop becoming an artwork or purely the result of technology? So we're going to get there in a minute. But first, I wanted to definitely touch upon this recent US Supreme Court decision in the Andy Warhol Foundation for the visual arts versus Goldsmith, because it's such a major case in copyright law. It's been quite some time since the US Supreme Court has made a determination in a copyright case. So IP lawyers in the United States, and I think around the world, have been anticipating or had anticipated this decision for quite some time. So this case, I don't know if the decision was so surprising. I did think that the judges would side with Goldsmith, and I think many lawyers thought the same. But I think what was surprising here were the two decisions. When you read the decisions in this case, I think it was about 90 pages long, and there was a majority opinion written by Judge Sotomayor that included, it was 7 of the justices had signed on to the majority opinion, and there were 2 in the dissenting opinion written by Justice Kagan, and they were both very, very strongly worded opinions. And you could see that the judges really kind of attack the other side. So the majority opinion sided with Goldsmith. And for some background, for those unfamiliar with the case, it involved this photographer, Lynn Goldsmith, who, interestingly, and I think quite notably, the majority opinion described a little bit of Goldsmith's work and did credit her as one of the first leading female photographers in kind of the music rock star scene, where she would travel and photograph rock stars and musicians in the 70s. And she made a name for herself as one of the first females in this industry. So she really, within that kind of niche industry, was well known. And she had provided a limited license for the photograph that you see on the left-hand side. She provided that license to Vanity Fair, and that allowed Andy Warhol to use that photograph to create a single silkscreen work that would be used for the magazine. Unfortunately, though, Warhol did violate the terms of that license, and instead he created 16 different works based on that photograph. And you could see one of the works that he had created on the right-hand side of your screen. So ultimately, that work, that were one of the infringing works, one of the other 15 works that Warhol created, ended up being licensed by Condé Nast after Prince, the musician, had passed away a few years back. At that point, Goldsmith learned of Warhol's infringing activity. She contacted the Andy Warhol Foundation saying that there was this infringement and she was entitled to some compensation. And what the Warhol Foundation did was acted preemptively and kind of aggressively and actually sued Goldsmith to say that the Warhol Foundation had a fair use to use this photograph. And really, so what had happened in the district court is the district court sided for the Andy Warhol Foundation, finding that the work was transformative. And in recent years, transformativeness, part of the first prong of the fair use analysis, transformativeness had kind of become the prong that had been given the most weight by courts. And Goldsmith challenged that, and she challenged it in the appeals court and won in the Second Circuit in New York. And the Andy Warhol Foundation challenged that decision and brought it up to the Supreme Court for the Supreme Court to look at that first prong of the fair use analysis. And the judges balanced or looked at that first prong. They didn't go through the entire analysis. They only looked at the first prong and considered in the opinion the balancing to protect artists versus the ability for others to use material and to build upon that. And the court ultimately decided with Goldsmith, found that just because someone is a famous artist and kind of puts their stamp on a work, their style on the work, isn't really enough. And that there wasn't that this transformativeness wasn't enough to allow for Andy Warhol to claim fair use. So it was a big case, and not to get too deep into decades of copyright law jurisprudence, um, but it leaves some questions because for a while transformativeness was really seen as kind of the benchmark of the fair use analysis, and the court is now saying it's not enough. And in fact, here one of the problems is that this had an effect on the market. Ultimately, with a really these facts are a little bit unusual, that the same photograph that Goldsmith had allowed to be licensed through Vanity Fair ended up being licensed again through Condé Nast decades later. And so there was this competition within the same market. And that was really important in the Supreme Court's analysis to see that, or to say that there was this competing market, and you could see it very clearly in this situation. So big change in the copyright world, and there are many people writing scholarly works on the case now, and we'll see how all this pans out in future cases. But I think legal scholars were also waiting for this decision to see what effect it would have with copyright questions relate to AI-generated artwork. So what challenges relate to AI art? So Miriam, the next slide, please. So I'll start here with animals that it relates in, and you'll see in a moment why copyright challenges involving animals relate to AI art. So within the past 10 years, the Copyright Office has stated that animals are not eligible for copyrights. Some of you may be familiar with this image. This was a selfie taken by this monkey. And when PETA, the organization People for the Ethical Treatment of Animals, tried to get a copyright and to challenge this and to say, well, animals should be allowed to do this. They are sentient beings and they might have an intention to take a photograph, to create a work of art. Copyright Office said copyright registrations can only be filed by human beings. So this excludes photographs and artworks created by animals or by machines without human intervention. So I think it's really interesting to think about that phrase, without human intervention. So next slide, please. In February of this year, the US Copyright Office released a long-awaited decision concerning the work by Christina Kashtanova and her copyright for her graphic novel called Zarya of the Dawn. So in fall of last year, Kashtanova received a copyright registration for her work, even though she failed to disclose that the book's illustrations were generated with the help of an AI image generator called Midjourney. After she received her registration, she then announced on social media that she received a registration for the entire work, including the AI images. In response, the Copyright Office actually backtracked and requested more information from the author about how the artworks in the novel were created. As a result of the information that she shared and the result of this process, Castanova was given protection for the text and the compilation of the comic book, but not for the images. So even though the artist had invested work in creating prompts to create these images, and she selected the images that were created by AI, the images were actually created by Midjourney technology. And as the Copyright Office stated, they are not the product of human authorship. Next slide, please. The reasoning goes that Castanova's prompts are similar to suggestions, and that the AI then takes those suggestions and makes its own choices, so the artist doesn't actually exercise control over the creative process. And thus, Midjourney is the true author, and Midjourney is not a human, so copyright cannot be granted. So while technology can serve as a tool for artists, here it's the unpredictability, this unpredictable nature of Midjourney's process that makes this situation distinct. So we're not looking at AI generation through Midjourney as a tool like Adobe Photoshop or other tools like cameras and other technology that artists might be using. So as a result of this matter, any copyright going forward, any copyright applicant must inform the Copyright Office if any part of its mission was AI generated. Because of this, in March, a month after this decision was made, the Copyright Office released a statement stating that AI generated art is not eligible for copyright. The office compendium, its guide to policies and procedures, explicitly states that works created by nature, animals, or plants cannot be registered. It also includes works produced by a machine or mere mechanical process that operates randomly or automatically without any creative input or intervention from a human author. So I was going to stop there to discuss what this really means. What is human intervention? And I think what's so challenging here is that when we look at the history of copyright, um, copyrightability, historically, this level of creativity is low. And this goes back, decades, that the Copyright Office has never actually defined what the modicum of creativity is, what's required to get a copyright. And we can look back to a case from 1991, one of the few times that the US Supreme Court has looked at a copyright case is the case of Feist versus Rural. And it actually involves telephone books, like these old kind of yellow pages, these directory of phone numbers, where there was a dispute between these two companies that were publishing these yellow pages, these phone books. And the question there was, what do you have to do? What is the creativity that's necessary? And in this case, it was the question of an alphabetical listing. So the court never defined what creativity is, but rather defined what creativity is not, saying an alphabetical listing of data is not creative enough to get a copyright. So we're left with these questions about creativity. What is enough? So we know an alphabetical listing is not. What would make AI generated art creative enough? It's not enough to put in suggestions where the result would be this kind of unpredictable artwork or unpredictable result. What is it? And the artist, Castanova's lawyer, had argued that the Copyright Office made a mistake, saying these were not mere suggestions, that the artist had to be creative in creating these prompts, in feeding information to these programs. So it wasn't that you put in random words or that this program like Midjourney created something on its own, that the process actually was directed by an artist. So we'll see how that plays out as the technology changes with AI generation, as the relationship between artists and these technologies change. So it's a really exciting area to be in. And I think that there are going to be a lot of challenges, and the Copyright Office, I think, is really going to have to be creative in how it defines creativity going forward. So, I'd love to hear other thoughts and Miriam to discuss these issues with you as well.
Thank you so much, Leila. That was lovely. And so many questions. It really is helpful to think about this as an ongoing kind of process that unfolds with emerging technologies. We have um, new, uh, newer and newer complexities, I think, every week, if not every day. And so I wondered if we might be able to begin with this question of, um, at Holo Art, what we've tried to do is to curate a lecture series or a dialogue series, and this caps our sessions for the first half of the year. And it's delightful to be here with you today. We wonder how to reconcile the two camps, and I simplified it to two camps. Artists. We had some guests who spoke very strongly about how artificial intelligence is taking away some opportunities for artists, and the way that generative AI works is ultimately tapping into the data that was crawled, and so how to opt out of that. I mean, it becomes a bit of a catch-22. And then the next piece, a lot of people generating, myself included, generating artwork with AI that is then shown or sold. What becomes of that copyright? How do you see that kind of playing out? And I don't expect you to have answers, in terms of a crystal ball, but what are your thoughts about? You spoke about the genesis of copyright and how it might, kind of, what are the scenarios that we might be looking at?
So it's a really challenging area because I think courts have grappled with these challenges for a long time, because art has always pushed the boundaries. And I've been thinking, and this often comes up with appropriation art. During the past couple decades, there have been so many cases involving artists like Richard Prince and Jeff Koons, artists who take the work of others and put these objects or these works in a different context or change them in some ways. And courts have not always been uniform in how they viewed these cases. Um, Often it comes down to really fact specific inquiries. Often there's been kind of some like conflicts between courts and not and making decisions that are not uniform. And so I think this is challenging, and it's been challenging for a long time, and now we're throwing in technology that's making it even more complex. But in terms of artists who feel that this technology negatively affects their ability to create art, there have been class action suits that have recently been filed by artists, and the claim is that this AI generated art does compete with them. So there are AI generated or AI generation that allows computers to create images in the style of specific artists. And in those cases, these artworks or this AI generated art is directly competing with artwork by an artist. So it'll be really interesting to see how that plays out, because one of the questions and researching this area and reading other scholarly works on this topic, some other lawyers have opined that it's difficult to actually try to sue for this. Like, if an AI generated work isn't created by a human, who are you suing? You're suing these larger companies. So I think there's some challenges in who to sue, how to sue. Are AI generated images actual substitutions? Do they compete directly in the market? I think when we see this, I think the Warhol case didn't give a very clear answer, but you can see that the Supreme Court, I think, was leaning toward the fact that these images do compete. They're in the same market. So there are a lot of challenges, and we'll see how these issues are decided by lower courts in the next, few years or decade.
Absolutely. And there's the additional complexity of international law. So you had a caveat at the beginning for us that you were primarily focused on US copyright. How do you see the, I guess, coming together of uh, copyright consensus?
So I know that other nations, some other countries do treat AI art differently or machine created art differently. And I know the United Kingdom does provide copyright for works generated solely by computers. So it'll be interesting to see how these issues come before UK courts. I know that the European Union is also in the process of drafting legislation concerning AI. So it'll be interesting to see how that works, the result is there as well, to see how that works in concert. So my expertise, to be honest, really is in U.S. law, not in European copyright or intellectual property law.
I,
But it's
I
interesting
guess
to
what I'm
see how
thinking,
issues are different.
Leila, is, when we speak of provenance, right, and we have these digital art auctions that occur in one continent, and then it's, if it's a print transported to another continent, how would that law, it would be on the, I guess, geographic location or where it was created, and how would that historicity, kind of follow the art piece, and
So
uh, maybe the question would be better asked uh, in this way: are there any efforts to create, global regulations around copyright when it comes to generative AI?
I unfortunately couldn't give you the answer for that, but what I would say is that if you are selling items and let's say you're creating art in Europe, or let's say in the UK, where you have more protection for machine created art, but then you choose to put those works in the stream of commerce in the United States, you could be liable for infringement in the United States because you are getting that benefit by selling the works in the United States. So there would be questions with forum selection, and looking at which laws would apply. So I think artists, dealers, collectors, sellers, anyone working in commerce would have to be mindful. Um, it's funny because it is so kind of new, and it's interesting to see how countries are grappling with this in different ways. Um, and obviously, it would be great if there was something more uniform. And I wonder if countries will be looking to see how the US Copyright Office has been dealing with this issue, because luckily the US Copyright Office has provided a comment, has provided guidance that making a blanket statement that animals, machines cannot get copyright, that copyright only applies to humans. So I think it's helpful that there are those statements, but clearly the UK doesn't follow that. And I know that not all countries follow that rule.
And then it becomes really interesting when, and I don't know if you have an answer for this, but just to, explore the question with you, um, Mid-Journey being released in different countries with the different, legal, I guess, requirements that are stated. Um, how does that factor into where you used Mid-Journey, or is it the software,
So I haven't looked at their licensing agreement or like the user agreement. I imagine there are I imagine there are provisions in that agreement that address liability for infringement. I can't imagine that there wouldn't be. I think any company that had that technology where they were taking other images and compiling them, and some of those images are copyrightable, or there's a creation of something new based upon something else, based upon other technologies and other art forms. There would have to be, I would imagine, in their user agreement. And I imagine it's very lengthy. I
yeah.
imagine there are clauses, and I imagine there are warnings as well that are provided to people using the technology about copyright infringement, just like,
There
any
are.
kind of.
Yeah. Absolutely, and they change. So as an artist, I I take a look and it changes continually, and sometimes a little bit more in stealth mode, it's not announced. It's kind of like snuck in there suddenly this week.
Even a Google search, you see, like, if you go do a Google search with the images, when
Mhm.
an image pops up, you even have that simple language that this image may be copyrighted. So I imagine a company like Midjourney or any of these AI software programs would include that type of language, that those warnings.
Sure, and that lends itself to the next question around, um, how do artists protect their work, both in terms of posting on the web that, these images can then be used by generative AI to inspire some of the other, images that are conjured, and then also artists who create works with artificial intelligence. Are there any provisions or any, good habits that artists can practice starting now, given that we're in the, I guess, frontiers of this landscape, and there will be a lot of changes to come.
So a couple things. One is, I think the simplest and the one that's been used for the longest, is to have that little C with the circle, the little copyright symbol under an image, and to have that copyright symbol with the artist's name, and perhaps even a warning that if you use this image without permission, you may be liable for infringement. The challenge here is when someone changes that image. So if you just have the direct use, that exact copy of an image, then I think an infringement case is much clearer. The problem is when these images are altered, and there's that question of whether the secondary user, or this user, the person who's changing the work and making the secondary piece of art, if they've transformed it enough. And what's even more challenging is to go that extra step to say, in the style of. And the problem there goes back to what we discussed earlier with what can you get a copyright of? It has to be something that's in a tangible medium and not an idea. So, in the style of is an idea, right? You want to do something that's kind of imitating, it's in another style, but you're not taking that exact copy of something that's tangible. You're putting your own spin on it. So, you could see how in the idea of could be transformative. You're taking another image, or let's say you said, I want to do a tree in the style of Andy Warhol. Andy Warhol never created that. You're taking a tree and putting your own kind of concept on it, your own idea. And you cannot copyright an idea. So that is really the challenge here, at what could be copyrighted. So my example to you, Marion, is you wanted to do something in the style of Andy Warhol, and it comes from your mind. The problem with AI generated art is if there's so much data I could see a situation where an artist lawyer would say, no, that's not really fair. You're not just being inspired by someone, but you're getting so much data that you're basically imitating and then interfering in the market and competing in the same market. I think that's where the challenge is, that AI isn't just inspired by an artist, but can actually take data to imitate and try to make something look at like it's by the artist's hand. So in some ways it's kind of forging, and we're getting into that area then. What is authentic? What is not? And that's a whole other topic, but I think AI is moving into that realm.
Thank you. And, I have two burning questions and some comments from the audience in terms of global regulation won't be possible. US and China and the EU have vastly different, interests. And there's a question about AI ethics as it relates to art. I'm not sure what the framing would be. Perhaps I can piggyback this notion of, companies pairing with, like the Adobe, Picasso, NVIDIA combination. Uh, what are your thoughts in terms of how that can evolve in an ethical way? The, the banks of images that we have available essentially are becoming anything posted online, even with the copyright symbol. An AI can pick it up and use it as inspiration, and so it becomes this, you know. Uh, cat chasing mouse or mouse chasing cat piece where it's very challenging to pursue in a legal manner. Um,
So perhaps that is a good time to bring in this question about ethics, that as this evolves and as this art becomes more prevalent and more people are being exposed to this art, creating this art, viewing this art, perhaps legislation as it's being written in the EU is necessary. And as legislation is written, there are these thoughts about ethics. And I'll go back to the creation of the US Copyright Act and why that was created. There was this balance that we want artists to create, right? We want there to be incentive for new art, for new creations. It's a benefit to our society to have that. And so we want to give artists some level of control so that they can monetize this and they can have an incentive. But that really does need to be balanced against public use and the ability to build on art, right? We're inspired by art that's come before us. So you want an opportunity for there to be dialogues with past generations, future generations, and different artists. And you need to also be able to comment on art. This idea of criticism and commentary and education is all captured in the fair use exception. So it's this balance. And I think that as AI and so many different facets of our lives, not just with art, but in all different areas of banking and finance and employment, as that becomes more prevalent, I think there's going to be more legislation that has to consider the ethics. And it's we're kind of now, let's see, 200, like 230 years, or yeah, 1790, so 233 years in the future, considering what was the Copyright Act intended to do and how do we kind of develop that with this developing technology. So I think there are going to be a lot of really interesting ethical questions about how to protect artists as well. Artists are still entitled to protection, and they should be. And I think that in the case of Goldsmith, the artist, the original artist, did receive protection at the end of the day, which was pretty incredible.
Thank you. And, as you were speaking, what was coming to mind was the next generation and how this value shift will essentially drive the ethics that are being mapped out for us. And I'm thinking of, I have two children, and they're under the age of 10, and they are producing works and referencing copyright. So one of them, wrote something and said, this is copyright free. And the other one wrote something and said, this is copyright. And so
Oh,
it's
that's
becoming,
great.
it's great, but it's also a little bit, curious, I think, for me, when we have pop songs and, our cultural zeitgeist is so focused on, copyright. Who owns this, this little riff? And we've had these kind of conversations in music as well. Was this
Yes.
inspired by? And I think, as you said, it's going to be something for us to explore. I wonder, how can we honor the past as our values change? And here I'm thinking of, the Statue of David that was recently banned. And, how do we have open, I don't want to say intelligent, but, respectful dialogue about these things when we have such vastly different values across continents, even within the same country, across states, across provinces, across perspectives? What might be, and this is a tall order, but I mean, I think you're up to the task in terms of being able to help us at least steer the conversation, which is what we're trying to do here at Holo Art, to spark dialogue across continents about this new technology. What impact does it have on the future of creativity? How people create, how children consider their creations.
So I also see a comment that mentions David, the David. Um, so it's really interesting that you brought up that issue because that is a very country specific dispute where Italy actually protects the copyright, the ability to use images of works from centuries ago, which really is unique. Most countries don't provide a government with such strong protection over cultural heritage images from centuries ago. And I think that's a really interesting issue and something that is being challenged in the fashion industry as well. So there's the image of David that was used by fashion companies as well as works by Botticelli and companies that were using those images that we think of as being in the public domain. They were brought to task for that and they were expected to pay licensing fees to the country of Italy. So really unusual kind of situation, and one I think that is unique to Italy in terms of how protective the country is of its cultural heritage, and as just a major source of revenue for the country. Most countries don't have copyright and ownership regimes that are as that protective. As we move forward, I think that courts and legislators are going to have to consider where we are in terms of art. So I mentioned that Brancusi case, and to today, that case would be really obvious. Brancusi created a sculpture. It's a sculpture that's abstract, but it's still art. And the court really found that to be a challenge to view abstract art as art. Today, that's an easy question for us. Very obvious. That was by Brancusi. Perhaps in 50 years from now, we'll see these cases as simple cases as well. Right now, they're challenging us the same way that 15 or 20 years ago, Jeff Koons' appropriation art was challenging. And he's been the subject of a couple of litigations where he had been sued for infringing. And there were different outcomes for the different cases involving Jeff Koons and his appropriation art. And courts really struggled with determining whether he had infringed upon other artists' works or whether his appropriation was transformative enough. So courts struggled with that 15 or 20 years ago. And perhaps 15 years from now, these AI cases will be a little clearer. But I think courts will evolve as our conceptions and as the public conception of art changes as well. And as we become more accepting or more open to different forms of art and of this mix between human creation with the assistance of or collaborating with machines.
That's a great place for us to, end our dialogue on as we get to the top of the hour. I think the last question I have for you is, do you have any final comments or, any thoughts you'd like to share with our audience? I think really the interest from the people who have supported our dialogue series is from patrons, collectors, artists, and curators. Um, I think you also alluded to the digital literacy required in understanding the different technologies and the licensing agreements, copyright use cases, and how different levels of legal decision makers can arrive at different decisions, not necessarily the same. And so, over to you for final comments.
I think it'll be interesting to see how these different platforms or different AI generation programs, how these programs will evolve to perhaps avoid these issues, like with Castanova, where there will be more control, even though there's this database, this huge database that allows artists to create new things, but allow artists to perhaps take a more prominent role in the creation to avoid issues of claims that these works can't be protected because they're solely made by machines. And I think it's going to be really interesting to see how other artists are going to challenge the Copyright Office on that, saying, no, this wasn't just machine created. Actually, putting in those prompts and being creative in the selection of terminology. It's like writing. It's like writing a book using terminology in a certain way and crafting that language. So I think it's going to be interesting to see how that area evolves and how the Copyright Office creates some parameters in how to define what human creation is versus machine, and when there's too much overlap or when it can be collaborative. I think it's a really exciting area, and we're going to see in art that marriage between human and machine.
Thank you. And Leila, as you were speaking, I had one final question pop into my mind, if you'll indulge me. I think it would be remiss of me not to bring it up as we sent some art into space. And, we had it beam back down to Earth from the International Space Station. I think the question for me becomes, as we move from a type 0 civilization to a type 1 interplanetary travel, what happens to space law when it's applied to art? And that question that you posed of, what is art and what is creativity? Where do we draw the line, especially in a future where it will be increasingly challenging to determine whether we're interacting with a digital twin, with an avatar, with a chat, a bot, or if it's another human. And so if we engage in co-creation, what is that? And then do developers have any, creative rights in the way that they've designed the conceptual architecture of the artificial intelligence? So that would be the final one, I promise.
So it's a very niche area, space law. I don't practice in space law. I don't think there are many people who do. I think it's such a small area of the law. But I think it's just like we were talking about different countries and copyright law and how we're looking for a more global regime, because there is, like, the internet is global, and the way we interact, the art market is incredibly global. That's one of the things that many of my clients are very mindful of, is how does art challenge? If you have the right to art in certain places, you might not be able to travel with it. You might not be able to export art from certain areas. So that's looking globally, but maybe we'll be looking at this issue more broadly to look at works that leave our planet within the next couple of decades, and what regulates the use and the exchange and creation of that art as well. But
Thank you so
you're
much.
at the forefront of that area, so maybe you'll be the expert I'll be asking questions to soon.
I think I can ask the questions, and I think really what is exciting is that there's so much new territory for us to explore together, and I'm really excited and so delighted that you joined us today in this dialogue. It's lovely to listen to you. Thank you for the presentation. Thank you for sharing your insights. And we'll share details about your law firm in New York and some of
Thank
the
you.
work that you engage in. Thank you so much.
Thank you. Bye.
Bye.